If you want to understand whether America's justice system can still enforce its rulings against someone who once held the highest office, you need to stop scrolling right now. Don't just glance at this. Actually pay attention. Because what we're witnessing isn't just another legal battle in Donald Trump's ongoing saga. This is something far more significant. This is about how the nation's top court operates when it chooses to move without public attention. Something extraordinary just took place. And that's not an exaggeration once you see the full picture. Reports indicate that a court decision was issued behind closed doors without any advance warning, without the usual public hearings, and without anyone tracking it beforehand. There was no media countdown, no leaks to Trump's team or his opponents. The judicial system acted first, and it did so quietly. Let me emphasize this point. America's highest judicial body reportedly made a major move before anyone outside knew a conflict even existed. This doesn't happen often. This isn't standard procedure. When it does happen, there's always a serious reason behind it. Based on available reports, this wasn't just a minor procedural rejection or a narrow technical matter. This wasn't the court simply dismissing something routine. According to sources, this was the Supreme Court pulling back a curtain. And what was behind that curtain changes our understanding of the entire situation. Reports suggest there's been a grand jury investigation running secretly for over 12 months. It was happening alongside all the public Trump cases we've been following, but nobody outside the system knew about it. Here's why this matters so much. The Supreme Court is designed to be open. Cases are normally heard in public. Timelines are published. Debates happen where everyone can see them. But there's a rare exception, a special power the court almost never uses. It can operate completely in secret when revealing information could cause serious harm. If these reports are accurate, that's exactly what happened here. That decision alone tells us how serious this situation is. For the first time in this way, reports describe a secret grand jury subpoena that moved through the entire federal court system and reached the Supreme Court without anyone outside knowing. Then came the critical moment, a 72-hour deadline to comply. Not weeks, not months, 3 days. This is where the story becomes less about one person and more about the system showing its authority. By the time this order became known, Trump's legal team was reportedly caught completely off guard. No time to prepare, no chance to control the narrative, no ability to plan a response strategy. Some reports even suggest that Trump's main lawyers didn't know this was happening. One morning, everyone thought all the legal challenges were visible and mapped out. By afternoon, everything had changed, and here's what many people will miss. This isn't described as just another case on top of the existing ones. Reports frame this as a completely separate legal matter, distinct from the classified documents case, the January 6th investigation, the Georgia election case, and the New York civil fraud situation. According to analysts, this represents a historic moment that virtually nobody predicted. Which brings us to the question we need to ask before going further. What could be so important that the system kept it sealed for more than a year? And why would the Supreme Court decide that right now is when that secrecy should end? What unfolds next is where this stops feeling like a drama and starts looking like the mechanics of institutional power. This is the part most people never fully grasp because it requires looking past personalities and understanding how the system actually works. Once you see it, you can't ignore it. At the heart of this situation is authority the Supreme Court rarely exercises. The court functions on transparency. Its power comes from operating in the open. Public records, scheduled hearings, decisions made visibly. But deep within its tools is a narrow, extreme option. The ability to work entirely in secret when making things public could itself be dangerous. National security situations, intelligence matters, cases where exposure could cause damage that can't be undone. According to reports, the ruling states this extraordinary authority is reserved for matters involving serious national security concerns. That's not just dramatic language. It's a legal threshold. Think about this. When a court built on openness decides that openness is the risk, the system has already shifted into a different gear. Based on available information, every aspect of this process was sealed from the beginning. No public documents, no televised proceedings, no trail for reporters to follow. The subpoena was reportedly issued over a year ago under complete seal, and it came with a gag order. Trump was legally forbidden from discussing it publicly, forbidden from rallying support, forbidden from turning it into a political battle. His attorneys were bound by the same restrictions. This wasn't just a legal case. It was designed to contain information. This is where the power struggle becomes obvious. Trump's approach has always relied on public visibility, pressure campaigns, and creating noise. This process stripped all of that away. There was no audience, no outrage to generate, just courts, paperwork, and deadlines moving silently. So Trump did what he typically does when institutions challenge him. He used his standard defenses, presidential immunity, executive privilege. He relied on his usual legal strategies. But this time, those defenses failed. Not in public view, not dramatically, quietly, step by step. First, reports say the trial court rejected his arguments. Then the appeals court did the same. Each loss happened behind closed doors, unseen and uncontested in public. By the time it reached the Supreme Court, this was no longer about delaying things. It was about finality. This is where the judiciary's tone reportedly changed. Chief Justice John Roberts allegedly wrote that the subpoena concerned conduct that falls completely outside any reasonable claim of presidential immunity. That sentence draws a clear line between holding office and personal accountability. Then came the phrase that signals escalation. No additional delays will be accepted. Read that carefully. That's not a request. That's enforcement language. And the enforcement came immediately. A compliance order with a fixed deadline, 72 hours exact, inflexible. Not a suggestion, but a ticking clock, and then the warning. Any refusal to comply will result in immediate contempt charges, both civil and criminal, including possible consequences like detention before trial. Courts don't use that language casually. It exists to remove all doubt. This is the moment where options vanish. There are no more appeals, no procedural workarounds, no room for negotiation. The Supreme Court has reportedly spoken, and the system has positioned itself to demand obedience. Then comes the substance, the reason this deadline exists at all. According to reports, prosecutors are demanding 3 categories of material, each raising the stakes higher. First, complete financial records dating back to 2015. Foreign transactions, loan arrangements, property values. This isn't a focused audit. It's searching for patterns, raising questions about money laundering, unreported foreign income, and potential violations of laws governing corrupt practices with foreign entities. Second, communications with foreign individuals whose names are hidden for national security reasons. That phrase alone narrows the possibilities considerably. Analysts have wondered whether this involves oligarchs, foreign governments, or intelligence-connected intermediaries. Speculation aside, classification at this level isn't routine. It suggests counterintelligence sensitivity. Third, and most significant, documents related to attempts to receive anything of value from foreign sources connected to election activities. That language mirrors federal campaign finance law almost word for word. Prosecutors use phrasing like that when they're building cases around specific statutes, not exploring randomly. This is where the system's pressure breaks through the defense. According to the New York Times, Trump's lawyers reportedly learned about the ruling through breaking news notifications at Mar-a-Lago. Sources described complete chaos. According to CNN, some attorneys are thinking about withdrawing from the case. According to Politico, someone cooperating with investigators has already given them a guide to what they should look for. Trump's response followed his instincts. Attack the judges, question their legitimacy, threaten not to comply. But this is where the situation tightens. Former federal prosecutor Andrew Weissman stated bluntly that those statements essentially invite contempt proceedings. At this point, intent doesn't need to be guessed. It's been stated openly. And when the judiciary reaches this stage, it's no longer watching words. It's watching actions. This is where everything narrows to a single critical critical point. No procedural escape route, no way to control the narrative, no time remaining to change the game. Donald Trump now faces two options, and both carry consequences he's reportedly spent over a year trying to avoid. The first option is compliance, hand over the records, financial information, foreign transactions, communications, election-related material. If he complies, the wall of secrecy immediately falls. Whatever he fought quietly and persistently at every level to keep hidden is no longer hypothetical. It goes to prosecutors. It becomes evidence. The risk stops being political. It becomes institutional. The second option is defiance. Refuse, delay, provide incomplete materials, and trigger contempt charges. Not symbolic contempt, not a procedural warning, but the kind of contempt the Supreme Court reserves for moments when its authority itself is being tested. The warning is clear. The consequences could include detention before any trial on the actual charges even starts. That's how unusual this moment is. The phrase "now hovering over everything" is one the system almost never confronts. A former president jailed for contempt, not after a guilty verdict, not after a conviction, but for refusing to obey the court. This is where the impact spreads. According to the Washington Post, Trump's allies aren't just concerned about this case. They're deeply worried about what it suggests. If one sealed investigation reached the Supreme Court without public knowledge, could there be others? What else might be moving through the system unseen, unannounced, and already far along? That uncertainty alone undermines every defense strategy built on the assumption that all threats are visible. Public opinion is shifting in subtle but important ways. According to YouGov, even among Republican voters, a fundamental principle remains: no one is above the law. That matters because institutions ultimately survive not just through power, but through collective belief in their legitimacy. Legal scholars are already placing this in historical context. Lawrence Tribe has described it as the most significant Supreme Court action since United States versus Nixon. Not because the situations are identical, but because the principle is the same. Power encounters a boundary. Secrecy encounters a deadline. Authority demands compliance. 72 hours, brief, intense, irreversible. So here's the question hanging over everything now. Will a former president comply with the Supreme Court, or will he force the American system to decide how far it's willing to go to prove that its authority still means something? Before you leave, share what you think in the comments. If this analysis was useful to you, please like this video and subscribe to the channel. Then turn on notifications so you catch the most important political developments as they happen day after day. See you in the next one.